Hello, everyone. Welcome to another episode of the Lifetime Legacy Lawyer podcast. I'm your co-host, Thomas Vick, joined by the other co-host, Seth Wilson. Seth, how's it going today?
Thomas, I'm doing great. Glad to have an opportunity to chat with you. It's been a couple weeks since we were able to get our schedules to align again here, so it's fun to have the chance to catch up and talk about, an article you had on your blog about the importance of what is probate, kind of understanding what that is, and sort of the highlight that there's just a lot of folks who don't know what that is and what it means for their family. And so I thought that was a really good kind of place for us to talk about.
Yeah, so the topic is, what is probate and why do you want to avoid it? And let's kind of start with that first question. What is probate? And I'll kind of lead us off here. Probate is the court administration process of settling somebody's financial affairs. And so whatever is in somebody's estate sort of passes through the courthouse in a way. The court has some kind of interaction with the family, some kind of limited oversight or very kind of rigorous oversight over the loved one's affairs. And it's a way of kind of gathering up all of the assets, having the authority to gather up all the assets, figure out what debts need to be paid, and then distributing those assets after debts have been paid, and distributing assets to the heirs or to the beneficiaries under a will. So that's in a nutshell, that's what the process is, but there's a whole lot that goes into it, and it is not a quick process.
Yeah, and that's often one of the most misunderstood things I think about probate is when is it required and how long will it take as a result? And I don't know about you, but oftentimes I will have an initial consult with a client who ran into a challenge trying to transfer an asset that was legally part of a probate estate. So like real estate, for example, and we listed the house with a realtor, and everybody kind of thought there might have been an estate because they were named as the personal representative in the will. And you get ready for closing and somebody says, well, who's going to sign the deed at closing? And the personal representative has never formally been appointed by the court to do that. So therefore, there's no one with legal authority to step into those shoes and facilitate that transfer. And so that's a time when folks will come to me, but that's a little bit of a challenge because now we've got to go back to the date of passing and recreate all the steps that have been done, or at least review them and make sure that they were in keeping with the intent of the last will and testament of the decedent. And so that can be a little bit more complicated than maybe folks were anticipating. It's obviously a little bit more expensive because of the time it takes to do that accounting and figuring out what was done. And so that's often the reality check for folks is, oh, I didn't know I needed to even open up a probate estate. And so that's something I see quite frequently.
Yeah, it certainly is a time-consuming process when you're dealing with a probate administration. When you go to file a petition to open up an estate administration, that in and of itself takes some time. The attorney's office, I think both of our offices are probably pretty efficient with getting petitions drafted, but it does take some thought in getting those things prepared and then coordinating signatures and then getting it filed with the court. And then maybe the court signs it the same day. Maybe the court wants additional information. Maybe they sign it a few days later. It just kind of depends on what the judge's schedule is. And then, you're probably appointed at that point in time. But then you've got these required waiting periods and deadlines that have to be met. The first one is you've got to file an inventory, or at least you have to prepare an inventory, and it needs to be an accurate inventory so that beneficiaries can rely on it, and if necessary, the court can review it and rely on what the inventory says, so the court knows what's going on in the estate. So that takes some time. That's part of the gathering assets, garnering assets phase of the estate administration. And then you've got a waiting period of at least 3 months to be able to really know whether there are going to be any claims filed against the estate or not. And, all of this is done in a public format, which most people don't want their dirty laundry aired out in front of the public, and so there's potential that your estate becomes a public record and people can figure out what's going on with it, and anything can happen really at that point in time when people can see what's going on in the estate, and if they have a claim, they can file a claim. All that kind of stuff gets into the analysis of, why is probate a bad idea?
Yeah. And on the flip side, there are some benefits to those processes, right? So when you have that claim period and it expires and a claim has not been brought against the estate, that claim is barred. And the claimant would have to show pretty substantial evidence as to why that claim would be valid as against the estate. And so there can be some benefit to that time period and process. But if you don't have access to funds while you're waiting for the estate to be opened up and the mortgage is due and the utilities and different things, it can create some additional challenge for your loved ones while they're trying to figure out, how do I get access to mom or dad's funds, for example, and then even making the determination of whether this is a estate that exceeds the small estate threshold, because maybe the house transferred on death by a transfer on death deed, but we don't really know the value of the accounts and whether we're above Indiana's small estate limit, so that an estate really doesn't need to be open, but maybe it does, and we're right on that borderline. Now you've got more attorney fees and time associated with putting all those things together. So yeah, just there's lots of considerations when you're thinking about what is that probate and should you avoid it.
Yeah. And, you think about the claims that can be brought. I do a lot of Medicaid planning. So one of the big claims that is out there for Indiana estates is Medicaid estate recovery. And it is a requirement of personal representatives to put Medicaid estate recovery on notice of the decedent's estate administration. And then if there is a claim to be brought, FSSA will bring it. And it's not uncommon for FSSA to have a $50,000 claim or a $100,000 claim if Medicaid has, provided a lot of services. And it might be that, somebody was in a nursing home and they still had a house in their estate, but the house was never sold. So the person died with that house in the estate. It's going to be pretty difficult to sell that house without having Medicaid estate recovery recover the funds from the sale of that house. And so thinking about what claims can be brought in the state administration can probably steer you in a different direction and how to avoid probate.
Yeah. Yeah. And again, we've talked about just the options for doing so on other podcasts in terms of having a trust in place, be that a Medicaid asset protection trust or a revocable living trust that obviously kind of locks into place when the appropriate time comes. But there's also other items listed that are really important, like your beneficiary designations, making sure those are up to date and don't sort of accidentally end up coming back into and creating the need for probate because that designation wasn't completed or something along those lines. And then obviously we've talked about kind of that during life incapacity of the power of attorney and how important that can be to help navigate those, or just as a matter of convenience to be a help for someone to step into someone else's shoes and handle finances for them if necessary.
Yeah. You might even call a guardianship living probate. it's in a probate court and overseen by the probate judge, and you don't want a guardianship if you can avoid it, and you can avoid it through a power of attorney. So that's certainly a great way of planning against that. And then the last topic of this particular blog post was what happens when there is no estate plan. And that's just begging for a probate administration, right? If you don't have a will, you're going to have to go to probate to be able to handle a person's final affairs. And so it's important to have a will so that you don't die intestate, and therefore leave your estate plan to whatever the state of Indiana's law says on who gets your assets. But as a part of not having a will, that means you're not authorizing the unsupervised administration of an estate, which means you could probably bank on having a supervised administration. And, that's oftentimes the situation that you'll have, beneficiaries, kids, parents, step parents, all kind of come into the probate court and have a contested probate administration that doesn't look too pretty when that happens. So you can save a lot of time, a lot of cost, a lot of heartache and bickering if you have a will, and especially if you have a trust that limits the forum in which those arguments can take place.
Yeah, it's such a good point, and you're just helping avoid the default rules that would apply, the legal rules that are in Indiana as to what happens if we need to determine who are your closest living relatives because you passed without a plan. And that can be a costly and time-consuming process in and of itself, trying to figure out, okay, this individual has passed away, but who all is entitled to notice? And who all needs to sign off on who is going to proceed as the personal representative? Who becomes the personal representative? All of these are open questions that you can answer by having your plan in place before the appointed time. And that ensures that things happen as smoothly as possible. And again, with that probate process, there's always opportunities there to have two beneficiaries who may not agree, and they challenge each other. And now you've got to decide, well, this may now become a supervised administration versus an unsupervised administration. And so that's going to affect the time it takes and the amount of money it's going to take to probate that estate because somebody doesn't agree with someone else serving in a particular role. And a lot of those issues can be avoided with a little bit of forethought and planning.
Absolutely. So just to kind of summarize, what is probate? It's the court administration process of settling somebody's affairs, their deadlines, and, kind of statute of limitations on what happens during that probate administration. It's a public forum. It can be costly. It can be time consuming. And so it's best to avoid it for those reasons. And you can't avoid it through trust creation, through beneficiary designations. Those are the two principal ways of avoiding probate. And if you don't have an estate plan, you're kind of begging for a probate administration. So that's kind of a summary of that topic. And Seth, I'll let you introduce the next topic for us if you'd like to.
Yeah, let me just add one thing, just because this bears repeating in terms of kind of our phrasing of these issues. So when you do a trust-based plan during your life, you're effectively doing the work of probate now. And so you don't leave all of these unanswered questions for down the road and opportunities for challenge. And so having that plan in place and setting up the accounts appropriately and funding the trust, retitling assets as necessary, and reviewing those beneficiary designations can take a lot of the challenge off of the family members who are there. So you do have quite a few other blog posts out. So I would encourage folks to check out the newsletter or the blog at vicklaw.org. But one of the questions one of the ones that kind of jumped off to me, because it sort of dovetailed with why this probate thing is so important, were some of these estate planning lessons from Warren Buffett. And kind of the news that came out there was he is using a will-based plan, and kind of some interesting things there. So we won't go through that necessarily on the podcast, but that's an interesting article to kind of think about. Here's one of the wealthiest men in recent history anyway, and what his plan is and how he's handling that. But I thought there were some good kind of indicators as to what he thinks of his family and his kids' ability to handle things that may be helpful resources as you're thinking about an estate plan.
Yeah. It's always good to look at Warren Buffett for financial advice, and so I would encourage everybody to take a look at that at vicklaw.org. Lots of other topics. I'll just kind of highlight some of the other topics that you can find there in the blog. Creating a senior life plan to reduce the burden on loved ones as you age is the topic. Another one is what is a second retirement and how to plan for it. And another recent blog post was estate planning for non-citizens with U.S. assets. So just kind of a tease out there for other topics that you can find information on vicklaw.org. Anything else that we want to talk about today?
No, just the comment that the second retirement thing is something that's very interesting, because you have this reality in life a lot of times where folks retire and they go, I don't like this. I'm ready for something else, and return to the workforce. And so that can bring a whole host of things to think about in terms of maybe rollover accounts and things from a prior plan and all of that. So that's a good one to think about as you're considering that, and as you're approaching those retirement years.
Yeah, absolutely. Think about Social Security and income taxes and all that kind of good stuff when you're thinking about coming out of your first retirement and then maybe going into a second retirement. So what's the best way to get in touch with you, Seth?
Well, we are located here in the heart of Hamilton County, up in Noblesville, Indiana, and that happens to be our website address, noblesvilleattorney.com, and that has all our contact information. How about you?
Best way to get in touch with me is by going to vicklaw.org. You can see the blog posts there on vicklaw.org, the ones that we talk about every time on this podcast, and you can also book a call with me on vicklaw.org. I think that'll do it for this episode of the Lifetime Legacy Lawyer podcast. Seth, we'll catch you next time.
Sounds good. Thanks, Thomas.